that since impeachment directly interferes with the sovereign will of the electorate expressed through universal suffrage, courts could not abdicate their responsibility by treating it as a purely political immune process. It was his case that the grave consequences of removal brought the matter squarely within the High Court's supervisory jurisdiction, requiring it to interrogate whether Parliament met the heightened constitutional standards. Senior Counsel Paul Mute submitted on the democratic mandate and the political question doctrine. He was emphatic that impeachment in Kenya's presidential system is an extraordinary constitutional remedy of last resort. He distinguished Kenya's architecture from parliamentary systems where executive tenure relies on legislative confidence. It was his case that the deputy president derives direct democratic legitimacy from the electorate through universal suffrage and cannot be removed due to transient political dissatisfaction or partisan convenience. In view of the fact that impeachment effectively overturns the democratic will, it was Senior Counsel's position that the Constitution deliberately imposed strict procedures and substantive safeguards that courts are duty-bound to enforce. Learned Counsel drew support from the decision in Mike Sonko Mbuvi, which we have stated, to restate that the threshold for removal could not be reduced to political expediency. He further called to his aid the Court of Appeal decision in Martin Nyaga Wambora, we have given citation, to argue that judicial review of the proceedings affirmed constitutional supremacy rather than offend the concept of separation of powers. He firmly rejected the respondents' invocation of the political question doctrine, asserting that the Constitution creates no autonomous islands immune from accountability, and he maintained that all constitutional power remains subordinate to the judiciary's review. Learned Counsel Mr. Chiang Dudley submitted on jurisdiction and the mandatory duty to adjudicate. At the outset, he pointed out an alleged internal contradiction in the respondent's case, simultaneously conceding the court's jurisdiction while urging it to abstain from exercising it. He submitted that constitutional adjudication could not be avoided simply because a dispute implicated political institutions or carried political consequences. He took the position that once allegations of procedural impropriety or rights infringements arose, the process ceased to be purely political. Drawing on the United States Supreme Court decision in Cohens versus Virginia, we've given citation, he argued that a court acts just as improperly when it declines constitutionally vested jurisdiction as when it arrogates jurisdiction it does not possess. It was his case that Article 165 imposes a mandatory obligation on the High Court to determine disputes whose constitutional violations are alleged as such. The judiciary would itself violate the Constitution by declining to hear politically sensitive questions. Mr. Ochieng submitted further that separation of powers does not establish institutional immunity and that judicial review ensures Parliament acts within its boundaries. Citing the Supreme Court advisory opinion in the matter of Kenya National Commission on Human Rights, Counsel concluded that constitutional interpretation in such disputes must be transformative, holistic, and purposive rather than mechanical. In the written submissions, His Excellency Gachagua specifically impugned Ground 8 of the charges, noting that it relied on Section 132 of the Penal Code, a provision already declared unconstitutional in Robert Alai versus the Attorney General matter. On the right to a fair hearing, he maintained that the Senate violated his inalienable right by proceeding in his absence due to illness, contrary to Article 50, Sub-Article 2F and Article 25C. He drew support from Karaoke versus Attorney General, where it was argued that denying an adjournment impacting a citizen's constitutional rights warrants careful circumspection. He further submitted that the rushed manner of the proceedings mirrored the predetermined and unjust actions condemned in Olo versus Kisumu County Assembly Service Board and another. rendering the resulting decisions absolute nullities. Submitting on public participation and institutional incapacity, it was His Excellency Gachagua's case that both houses entirely failed the threshold. He referred to the decisions in Mohammed and 6 others versus County Assembly of Wajir and other cases which we have stated. To reinstate that engagement must be substantive, one that allows reasonable time and utilizes satisfactory mechanisms. In addition to the foregoing, His Excellency Gachagua, while drawing support from the Decision Independent Electoral and Boundaries Commission vs. Attorney General 2025, discredited the involvement of the IEBC, arguing that constitutional functions requiring commission approval could not be lawfully discharged by the Secretariat without a properly constituted commission. In their rejoinder submissions, the legal team also spoke to procedural illegality in plenary investigation. It was His Excellency Gachagua's submission that the Senate lacked a lawful resolution to appoint a plenary investigation. They submitted that the word may in Article 145, sub-Article 3b, regarding the appointment of a special committee is a mandatory obligation, relying on a set of authorities, including Sony Holdings versus Registrar of Trademarks and another. They submitted that courts routinely interpret may as mandatory to effect legislative intent, to effectuate legislative intent. Tracing the constitutional drafting history from the Guy and Bomas drafts to the Wako and Harmonized drafts, it was their case that it proved the framers consistently intended for a special committee to investigate charges prior to any plenary vote. In conclusion, His Excellency